My question is, if the social worker recommended some case plan for us to do, parents to comply with, and the court order that, are we allowed? Our parents have a choice to do with their own vendor.
Stories and questions. First call is from Jay from California. Jay, did you have a story to tell or a question to ask?
I have a question to ask and a story to tell, Mr. Vincent. Good evening.
Good evening.
Can you hear me?
Loud and clear, sir.
Okay, just 1 second. Let me turn on something.
Jay, this is a live radio
Yeah,
show.
I can. Yeah. I have a question to ask, Mr. Vincent.
Yes.
My question is, if the social worker recommended some case plan for us to do, parents to comply with, and the court order that, are we allowed? Our parents have a choice to do with their own vendor.
You know, that's a very good question. That's a good question. You know, generally, in my opinion, you're allowed to do with your own vendor as long as they're qualified. But, you know, I've been in a lot of counties, especially in California, where the judge kind of leans towards using the CPS approved vendor, right? So that's something, you know, since you're in California, you must have an attorney, either court appointed or private. That's something that you should discuss with your attorney.
And if the judge did not order that we take the the classes or whatever the case plan to the vendor that of their choice, but the CPS, the DSS insists that we only do the from their vendor, are we supposed to comply with that, or we can do it from our own?
You know, it depends. That's something that you're going to have to speak to your attorney about. You know, you're asking me a question kind of in a vacuum. I don't know the whole story of the background. So, you know, this is the type of thing that you have to discuss with your attorney. You know, but the general rule, in my opinion, is you can use your own vendor as long as the vendor is qualified. Now that
qualified vendor.
Yeah, that what qualified to you might be something different to qualified to the social worker, right? And something completely different to as to the judge. So don't think that just because it's qualified to you means, well, you can use your own vendor. Because there's there's two other opinions, at least two other opinions that you have to listen to, and one of the other opinions is going to be actually a third opinion, the child's attorney. Okay, so this is definitely something that you should talk to your attorney about.
And my second question, Mr. Vincent, if the child already placed back with the biological mom for 2 months, not permanent, for 2 months, are they most probably going to close the case?
Oh, I couldn't tell you without knowing the facts of the case. You know, in a lot of cases that, you know, they will close the case on the next 6-month review. But in a lot of cases, you know, they'll want to keep it open maybe for another 6 months. That's something, you know, that's unique to each judge with respect to how they view the facts of the case. You could get a judge that wants your case terminated, or you could get a judge that thinks that another 6 months of, you know, services should be offered to the family.
So if the child been placed with the biological mom for a period of 2 months, I don't understand, is it why they not placing permanently? They just giving time to review, and the visitation still if we have a positive visitation, like me, I have a positive visitation with my children, but they just want to do supervised visitation instead of unsupervised, like the social worker are controlling everything. How we can overcome that, this issue.
Oh, you're probably going to have to overcome it with certain facts, in your case. You know, I get the feeling you're looking for a black or white answer, and it's not. The law is gray, and it depends upon certain factors, the background, the experience of the children, the attorneys, how the judge views the case. So I can't tell you can just use your own vendors for your reunification services. I can't. It sounds like that's what you would like me to do, but I can't do it. Okay? It's not one of those.
Hey, you called us last week, right?
Yeah, I did.
Right, and you had fired your attorney or something, and you were trying to file your own 388?
Yeah, I filed the 388. We have the Marston hearing, but unfortunately, as always, like the judge don't honor that. He still want me to have the attorney to represent me. I told the judge very clearly that I do not want this attorney to represent me because he's not presenting evidence, witnesses as what it was promised. And I lose the case even though I did not even spank my children. My children been removed, just because they retaliate against my pending civil case against them. So I say this is very harm. But I make a lot of. I see my case go to appeal court, and appeal court every time the attorney say that's no argument points. But I don't believe that, so I start putting points and all the evidence to the appellate court so that they can understand what I'm coming from, what is my point in stating, what is the actual problem, so they can understand that. But so the only thing is I start filing. A lot of people say, hey, why you were filing 388? Why you file a lot of papers? Document your own. I say this is my attorney job. But if my attorney don't do it, then I'm stuck. And in order for me to tell the judge what is happening is for me to start writing the letter to them, present the evidence to refute all the allegations that make against me. That's the only way. Because so far, I've been. It's very challenging for me that they don't understand what is the actual problem. Like I have an ailing child who have a medical condition. They don't want to understand that, and they keep giving the child medical condition a problem, and it's too much for the family to handle that, and they keep giving it. But when I make them know about this one, I say, hey, isn't it your department responsibility when you all take the children to make sure and ensure their medical needs been provided? It's not a parents when you take away the children and place them with a stranger, especially foster care. You cannot say just dump it down there. And then the children get hurt, have serious harmful medicine, and they did not documented anything about that. They only want to document something that what is in favor for them. I say, what about what is happening, the facts that happening, why it's not documented in the report, So I say this is without a clear convincing evidence, the children just been removed just like that, So that's the thing.
2 minutes.
It's happening. So, yeah, but one child has already got medical problem, and luckily these two children, I put too much pressure, so finally they placed back with the biological mom, But they're trying to break up my family marriage, So I say they have no right to tell another parents what to do. Let them decide. Let the wife make her own decision whether she wants to continue the marriage or not. It's not the social worker job to tell them to do this, do that. Put restraining order against your husband.
1 minute.
So did they tell you had to divorce? Did they tell you needed to divorce, or was it already in the process, or?
No, see, my wife, first she filed the divorce, but then after that she did not serve me, already coming to almost a year right now,
Right.
So
I remember your from last week, so that's why I was asking. I didn't know if your caseworker insisted that it happened or if it was already in the process when CPS was involved in your case.
No,
20 seconds.
I was asking.
Hey, Jay.
They just putting
Jay.
yeah, go ahead.
I'm sorry.
Yeah.
My engineer is telling me we have to take a break. I want to thank you for
Yeah.
calling.